You're going to represent yourself?
Yeah, sure.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened. It's
Pardon?
the incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. What do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a
Okay.
discovery. I don't know exactly what the procedures here is. You know that wrongfully.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you have
because I'm told to be here today, Your Honor. That's all.
I know, I know. I
So what I want
It
to
kind
do,
of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
yes,
this?
yes, Your Honor.
You don't want apprise you if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to, and the court will not play fair.
Right from the start, this judge isn't playing. Notice how he lays out the charges and immediately warns the defendant about the dangers of self-representation. This is a felony resisting and obstructing case, not a traffic ticket. The stakes are high, and the tension in the room is real.
Until
Suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede the fair my case, that I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court.
Here you can see Daniel trying to argue Miranda rights and suppress police body cam footage. But he's confusing criminal procedure with public release of evidence. The judge quickly spots the misunderstanding. This is a textbook example of why representing yourself is risky.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best.
Then
you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but
not sure what you're asking me. What are my options, sir? Your Honor.
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do
Yeah,
and maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because
Appreciate
otherwise this thing could much go.
This is one of the most brutal exchanges. The judge literally says, "This was your best." You can almost feel the frustration. Judges see hundreds of self-represented defendants, and the biggest mistake is walking in with Google law arguments instead of real legal preparation.
For discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely, Your Honor. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in a police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people don't intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within.
I really would be
grasp.
objecting to the defendant showing anything to the court that he has not disclosed to the people.
So given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is. I've known him for 15 years. I was with him throughout the course of the night and was.
So you want his medical records?
I want to, first of all, subpoena him to get his witness statement on.
Daniel's next move, trying to get a witness's medical records, crosses a hard privacy line. In criminal court, you can't just demand a third party's private health records. The judge patiently but firmly explains state versus federal procedure. This is law school level stuff being hashed out in real time.
Maybe that's the disadvantage of being pro se.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing. And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have hearing, but I do have an issue if he's trying to say that he can't do anything until we.
This is the moment everything breaks. The judge flat out says Daniel doesn't know what he's doing. It's harsh but honest. For anyone thinking of self-representation, this is the wake-up call.
Adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any time. You'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you.
And Your Honor, for the record, I put the email address.
Even after all the confusion, the judge still grants a short adjournment, basically a pause, so Daniel can regroup. But the hint about a competency evaluation shows how far off track this has gone.
The defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case, but I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Me. Yeah, let me at least have some turkey before I have to deal with this again. December 5th, 2024. So, folks, if you haven't figured out why, I'm going to take a brief break. Then I will come back and start the 2 o'clock block and we'll roll through it. But I'm not going to go from that to that. Court stands in recess.
All right.
As court wraps up, you can feel the exhaustion. The judge's final remarks aren't just about Daniel. They're a warning for anyone trying to run their own defense without understanding the system. It's a powerful reality check.